Afternoon, and welcome to NCBP's 21st Century program on the implications for bar associations of the Supreme Court decision in Janus versus AFSCME. Ever since the Supreme Court granted cert in this case, the legal community has been abuzz when the court rendered its decision on June 27, 2018 in favor of the plaintiff, closing the door on Illinois' closed shop requirements. There was immediate concern over what this would mean for mandatory bar associations throughout the country. That concern intensified when on December 3, 2018, the court granted cert in Fleck versus Wetch, involving a challenge by a lawyer member against the mandatory state bar of North Dakota. My name is Sharon Stern-Gerstmann, and I'm the immediate past president of the New York State Bar Association. And together with Lori Budwig, a past president of the Michigan Bar Association, we're the producers of this program. Our panelists today are Janet Welch, the executive director of the Michigan State Bar, and Emilio Veronini, the vice president of the newly formed California Lawyers Association. Janet has been the exec of the Michigan Bar since 2008 and came to the Michigan Bar with considerable experience as counsel to the Michigan Supreme Court and as staff attorney with the Michigan Legislature. She serves in the ABA House of Delegates and on the Standing Committee for Bar Services. Emilio works in the Antitrust Division of the Office of the California Attorney General, and he is active in the ABA's antitrust section. Welcome to both of you. Janet,
thank you.
Can you start us by summarizing the Janus decision and why there are such broad implications for mandatory bars?
Well, Sharon, it isn't really necessary to go much further than the way you've already described Janus. It was a challenge to the status quo concerning the ability of public sector unions to require public sector employees who benefited from the lobbying by the public sector union to pay an agency fee. The case that Janus overturned was a case from the 1970s, Abood, a much celebrated case, and its implications for bar associations. The reason that mandatory bar associations were paying close attention to what happened to Janus is that the Abood case is the case that the court relied on most heavily in the last decision that the U.S. Supreme Court issued concerning mandatory bars, Keller v. State Bar of California in 1990. But the analogy of unions to bar associations and bar associations to unions predates Keller and even Abood, and it's worth noting that the first challenge to the mandatory bar to appear before the Supreme Court in 1961 referenced a union case from 4 years before that.
Janet, before you go further, there are some of our audience members are having some difficulty hearing you. If you can keep your voice up a little bit louder, that would be great.
All right. I don't know how far back to go. I think we were in
1961
at this point. So the Lathrop case, which was a challenge to the mandatory Wisconsin bar, referenced the Hansen case. The Hansen case 4 years before had said, we think it's just fine to require non-members of railroad unions to pay some of the costs of what they get the benefit of, and it's no more a violation of the First Amendment than it is for lawyers to be required to be members of bar association. So the analogy between unions and mandatory bar association goes back to the very beginning of the debate about what you can require non-members of unions or bars, non-members of unions to do, and what restrictions mandatory bar associations might have as a result of the fact that they're mandatory.
Maybe you can talk a little bit about the Fletch case directly. What are some of the issues in that case?
So Fleck was filed as a challenge to the State Bar of North Dakota, coincidentally, the first bar to be made mandatory in the country prior to Janus. And all of the arguments that were made in that challenge were parallel the arguments that were made in Janus by the non-member of the union in Janus. And in fact, those arguments sort of are amplified by the result in Janus, which was a very broad decision, very aggressive about the scope of First Amendment protection. But the majority opinion did not reference mandatory bar associations. And in fact, the only reference to mandatory bar associations was in the dissent by Justice Kagan, which explicitly said that this decision does not reference mandatory bar associations. So that's the question that's open. That's the question that the court has sent back to the Eighth Circuit. Are mandatory bars like unions in relation to the reasoning in Janus? And that's the briefing that's been done so far.
How did the challenge arise in Fleck? What was it that the North Dakota Bar Association did that the member took issue with?
So the North Dakota Bar Association used member dues in an effort to defeat a ballot initiative that was in fact defeated, that promoted fathers' rights. It was not an action that many, maybe even most, mandatory state bars could take under the restrictions that have either been imposed upon them by their overseeing authority, the Supreme Court, or by their own restrictions. And the North Dakota Bar prevailed in the Eighth Circuit based on Keller, and although they had to make certain adjustments in the way in which they accounted for their activities to satisfy the Eighth Circuit. And what the U.S. Supreme Court has done is vacated the Eighth Circuit opinion and asked it to issue a new opinion in light of Janus.
Are you aware of other states that have similar challenges pending?
So there have been two challenges raised post-Janus. One out of Oregon that was precipitated in part by a publication of the Oregon State Bar. And the other one within a day or two after that out of Washington in the form of an amendment to a case that's already before the Ninth Circuit, challenging the Washington State Bar Association on other grounds, but this adding the Janus-based arguments against the mandatory bar. So those are the two that are out there at this point.
Now, sometimes the challenge comes not from members, but directly from the legislature or the body that sets dues. So Emilio, if I can turn to you, I understand that over the years, there have been several battles between the State Bar of California and the state legislature, and it sort of takes the role of funding and setting of dues, that when the legislature likes to punish the State Bar, They basically defund them by lowering dues. Can you talk a little bit about that history and then the final determination, how it came about that the sections of the State Bar of California were formed into the California Lawyers Association?
Sure, Sharon, and thank you very much for having me participate in this esteemed panel. I look forward to the panel discussions and to questions from the audience. But to back up a little bit, the State Bar, when it sets dues, does so both in accordance with direction from the legislature, but also our state Supreme Court. So the State Bar has a unique autonomous status under our Constitution. But nonetheless, over the years, this, of course, has given rise to various issues involving fee setting. So those issues involve, whether the State Bar is in fact fulfilling a key part of its mission in terms of licensing and regulation of the profession of lawyers. And when we think about that, there's sort of a broad range of issues just inherent in that I know we all know, but just to make sure we're on the same page, that range from administration of the bar exam to certification of an attorney as being in good standing, to ongoing licensing and discipline issues, and even to advanced certification, for example, certification in the specialization of appellate law as just one example of what the State Bar does. But historically, our State Bars also had a whole second sort of set of missions associated with it. Part of that was acting as the sort of arm for attorneys to both educate their members and to present the views of their members on both specific legal issues and on issues that affect the profession of law. So our sections, as such, originally came from the State Bars looking to the American Bar Association as a possible model. And the sections over the years evolved a number of different activities and functions that they do, ranging from education of the members to facilitating the exchange of ideas. But what's also been part of the State Bar's historic mission has been ensuring access to justice and diversity in the profession, and also helping give the profession access to general services such as mental health that the profession needs. So what's happened over the past couple of years, and certainly the fact that cases like Janus were around played a role, but it really wasn't the principal role, was that all of the actors in this system, the state Supreme Court, the State Bar, and the state legislature, all thought about, well, what is it that the State Bar should be really doing? And what is it that maybe should be spun off to a different organization? And so as a result of that dialogue and that process among many different actors, everybody came to the conclusion, I think it was a consensus by the end, that really what should happen is that the State Bar of California should concentrate on licensing and discipline and associated functions that fall within that. And that really other professional association type of function should be spun off into a new organization. And that organization would cover what the sections have traditionally done, but also would have more freedom to be able to act on behalf of all lawyers. In terms of the California situation, I think you can all appreciate how the State Bar had to be very careful every time it might want to weigh in on an issue of import to attorneys as attorneys, because they always had to be mindful of the issue about their dues and making sure that the state legislature and the state Supreme Court and everybody else understood that they were really focused on licensing and regulation. Now, with the formation of the California Lawyers Association, we are free as attorneys to focus on issues that bear on all of us as attorneys. So that separation was an amiable one. It was fostered through legislation. The association was set up in a manner in which each of the 16 sections, plus CYLA, which represents young lawyers, that is, lawyers who've been in the practice for 8 years or less, would each have a vote on what would be the new board that would go ahead and govern the California Lawyers Association. And so we have a structure with this board with one representative for each of the sections plus CYLA. And so we have both a chair and a vice chair of that board, but we also have a president and vice president. And so the idea is that the president and vice president could speak more towards issues that are CLA wide, as well as handle our external relations with our sister bar organizations, such as all of you, with which we're looking forward to reestablishing and deepening our ties. So at the end of the day, we've come out in a place where I think all of the institutional actors are very happy with where we all are. We enjoy a close relationship with the state bar. We're undertaking a number of other functions that the state bar used to undertake, such as the annual meeting and setting up what was always sort of a parallel annual meeting for our sister local bars and ethnic bars. And so really it's for us, and I'm not saying California should be a model for anybody else. We had a peculiar setup to begin with. But for us, it's worked out pretty well in terms of coming out the other side. Our membership stayed stable and our finances have looked good.
That's terrific. Always happy to have a happy ending to what had been perhaps decades long of a battle. Janet, you've alluded to the fact that many mandatory bars have restrictions on being able to take any position or have restrictions on what activities they can engage in. So in light of Janice and perhaps Fleck, a couple of questions that you and Emilio and even our audience, if you'd like to chat in some suggestions and answers. But first, how do mandatory bars avoid lawsuits from their members based upon Janice and maybe Fleck? And what's left? Can they speak out on anything? Is there anything that's considered fair game and not sort of wading into troublesome territory?
Well, the rules of the game until Janice, and I would say, and post Janice, because we're not sure what the U.S. Supreme Court will say about the implications of its reasoning in Janice to bar associations who have a mandate from their own state Supreme Courts or legislatures. The rules have been that mandatory state bars can engage in ideological activity related to the regulation of the legal profession or improvements in the quality of legal practice. And those are fairly broad and Keller recognizes amorphous subject matter areas, but states have evolved different ways of describing, what the boundaries of those subject matters are, and frankly, have survived without a lot of challenge. The sorts of challenges to the mandatory bar that have come on individual issues in which members are using the union construct and saying, give me some of my money back. A number of states, Michigan being one, Florida being another primary example, have shaped their lobbying activities and their public advocacy around the strict boundaries that we think are laid out in Keller, and have processes that show that we're thinking in every case about what those boundaries are. So one of the potential responses to the challenges, well, to Fleck and to any other challenge, is to rely on those processes and on the sort of the mandate that the sanctioning entity, in most cases the state Supreme Court, has given to the bar specifically because the bar's input on issues in those subject matter areas is valuable to the court, to the legislature, and to the public.
So, for example, obviously the conduct of CLE is something that we all recognize that mandatory bars can and should and do provide for their members. What happens when you have a panel on a CLE program where opinions are expressed that might not comport with the views of the member? Is there a risk of lawsuit in a post-Janus world?
Those are not lawsuits that I'm aware of having arisen under the current structure, and I don't know that Janus fuels those challenges anymore. I think it's important that every mandatory bar association be clear that when they are taking a position that speaks for the whole bar, how they arrived at that. And panelists' opinions expressed in the course of a CLE is not an endorsement of that position by the mandatory bar. I mean, you have to be really clear about when you're speaking, why you're speaking, and the processes that you've engaged in to speak on whatever the issue is.
And what did California do before the sections were spun off into the California Lawyers Association?
Well, I want to be very careful here not to speak for the state bar. I mean, among other things, we are separated from them, so they can speak for themselves. But what I'm willing to say is that the state bar was very careful about when they spoke on various issues. I think as a practical matter, when you have to worry about your dues and making sure that the state legislature is confident in what you're doing and that the state Supreme Court, to whom you're responsible, is confident in what you're doing, you have to be careful about when and how you speak out. And so for the state bar prior to separation, it was very, very careful. I think that's fair to say about when and how it spoke out for precisely these reasons that you're all talking about that antedate Janus and will continue no matter how Janus gets resolved. That's why there's been a number of issues that we felt as the California Lawyers Association, or even with respect to our individual sections, which had a history of commenting on legislation even prior to separation, that at least for us personally in California, we have more freedom to speak out than we had before. But that brings up a final point. Even prior to separation, our sections did have a good relationship with the legislature and were, for lack of a better term, sort of technical experts that the legislature could call on to advise them on various issues. Now, there, again, they had to be limited and judicious, and even post-separation, they still are. I just want to be clear about that. But there have been, at least for California, ways in which various issues that were of import to practitioners could be heard by the legislature from practitioners and from a practitioner perspective. But to be clear, there were informal limits because our state bar wanted to be very careful, even prior to Janus.
Janet, maybe you can comment a little bit on how you've seen Michigan evolve as a mandatory bar, as the perhaps some contentious issues came up before your board as to whether or not caution would be exercised before a position was taken.
So the history of the mandatory bar in Michigan is a history of continual refinement of our public advocacy. The first big challenges to Michigan's public advocacy occurred in the late 70s, and that caused the bar to rein in its advocacy. I think it had spoken out on anything it wanted to speak out before the challenges in the 70s. And then, of course, after Keller, we had the subject matter that was defined by Keller. We had a, excuse me, we had a political challenge in 2014 when we asked the Secretary of State in our state to amend the rules that she had the ability to amend in order to promote disclosure of campaign contributions to judicial candidates. And we faced a political backlash for having taken that position. Our reasoning was that it fell within the boundaries of Keller. But in the aftermath of taking that action, we refined our processes for taking positions and are much more rigorous in explaining why we take the position. We require a supermajority to affirm that they believe that the position is within the boundaries of Keller. And we're on the other side of that political maelstrom as a result of having adjusted our procedures.
Do you have a hue and cry from some of your members that the State Bar is not able to speak out on issues of import to lawyers?
I think there are always people who are passionate about causes who wish they had the State Bar on their side. And I think one way in which that pressure in Michigan is handled, and it will be interesting to see if this survives Fleck or any Fleck predecessor, is that our sections are not circumscribed other than within the jurisdiction of their subject matter. They're not circumscribed in what they can advocate on. So that gives an avenue for members of the bar to come together and come together as members of State Bar sections to speak on particular issues.
What happens if there's unfair criticism of a particular judge or a lawyer who may be defending an unpopular defendant? Is there any, do you feel any hesitancy to speak out on those issues?
Well, we've worked with the Judicial Council that is part of our structure on rapid response techniques, but the bar itself is really careful because we're one of the states that has an elected judiciary. We're really careful not to speak out on particular judges or judges' behavior at any point, and in particular in the course of a campaign. But I think the sort of help that any bar association, mandatory or voluntary, can provide outside of the political implications of speaking about an individual is to have ready sort of generic responses. For example, one perennial unfair criticism that arises about judicial candidates is if criminal defense lawyer is seeking a judicial office. Often part of the unfair criticism is to equate the lawyer with the bad behavior of some of his former or her former clients, and to have, I think the mandatory bars and voluntary bars can have ready a defense of what it is that criminal defense lawyers do and the importance of that work without speaking, about the quality of an individual candidate.
And what happens if the criticism comes from an elected official? Does that change the ability to speak out?
I would say no matter where the criticism was coming from, we would have the same restraints, and which is not to speak about an individual candidate or judge, but to point to sort of the underlying issues that might be unfair, sort of the perennial ways in which judges or candidates are, or the practice of law can be misconstrued or misrepresented.
I know as president of a voluntary bar, there were times during the current administration that we needed to speak out because there was unfair criticism of a judge because of his or her ethnic background, or because of his or her appointing president, or something else. Is that something that mandatory bars now have to hesitate before they can speak out against, or are they free, like most of the voluntary bars in this country who did in fact speak out in favor of the judiciary, in fact, as did Chief Judge Roberts speak out on the last occasion?
Yeah, so I'd be interested in what some of the folks who are listening in have to say about this, but I would say that the mandatory bars restraints in that area are not heightened by Janus. I think that the political considerations apply to voluntary bars as well as mandatory bars. We know a number of mandatory or voluntary bars that have lost members because of actions they've taken that their members have construed as political or not consistent with their understanding of the issue. So while mandatory bars have constraints, and the constraints are pretty well defined by Keller, I don't think that we're uniquely constrained.
Yeah, if I could jump in here for a moment with a voluntary bar perspective. I mean, coming from that perspective, we're very careful not to want to weigh in on political issues. We have a whole formal structure that we put into place to make sure that when we weighed in on issues, it would be in a non-political way on non-political issues. But in thinking through this example that you all have been discussing, there's sort of a difference between getting involved in sort of the politics of picking judges, selecting judges, voting for judges, versus issues about whether a judge gets attacked solely because of their ethnic background, or the judge makes an unpopular decision and is subject to a retention election. And in that context, our association, and I think all of the associations, are very mindful of the need to figure out ways in a non-political way that we can defend judiciary against these kinds of attacks that undermine the rule of law. So distinguishing sort of the political process and what's political from our non-political role, I agree with Janet. That is something that's as important for voluntary bars as it is for mandatory bars, even though we in the voluntary bar side don't have the formal restriction of Keller per se.
Now, one of our participants from the Mississippi bar commented that the Mississippi bar does not get involved in any remotely political issues. And this individual used the example of tort reform, that they said the Mississippi bar did not take a position because the mandatory bar is made up of both defense and plaintiff litigators, and there was no consensus. I can tell you in voluntary bars, there may not be a broad brush in either espousal or attack on so-called tort reform, but in due course, various provisions that are perhaps under the tort reform moniker do come before the voluntary bar, and the voluntary bar does take positions on that. Do you find that mandatory bars are pretty much across the board constrained from doing that?
So I have just gotten the results of a survey of all the mandatory bars. 24 states have responded, and I can say we are all over the map on that issue. I mean, everyone understands that they need to be constrained by what Keller said, but we all interpret Keller differently. And so that's why you have the State Bar of North Dakota finding itself defending an action about activity concerning a ballot proposal. And then you have states like Mississippi. Mississippi is not the only one who is very constrained in what they do. On the other end of the spectrum, and we're all across the board in how we've responded to what our scope of advocacy is.
There's also a comment from the Rhode Island Bar Association, and they have a policy that they have developed with respect to responding to unfair criticism that they think perhaps jeopardizes the independence of the judiciary. And then they have a referral procedure and guidelines to determine when the bar should and should not respond. And I'm sure that is, though not all mandatory bars may necessarily have such a process, I think in light of some of the challenges that Janice and Fleck might present, I think that sounds like a very good practice to have. Would you?
Could I say that I think, well, I wish that Janice hadn't happened and Fleck was not out there. One of the upsides of the spot we're in is that mandatory bar associations are talking to each other better, and I love to know what it is that the Rhode Island Bar Association has done, and I think we will all be stronger with the communication that we have as a result of this challenge. So thank you to Rhode Island.
We are now up to about 5, if I'm doing the count correctly, about 5 voluntary lawyer associations that are present in mandatory jurisdictions. So like California, there's a separate voluntary lawyer organization, and there's one I know in District of Columbia, in Virginia, North Carolina, and we believe West Virginia as well, that have established these voluntary organizations, perhaps to do some of the things that Keller or whatever other constraints may exist on mandatory bars. Do you think there are going to be more? Do you think that what has happened in California, though it might not be directly related to Janice, is likely to spread throughout the country? Or do you think that depends on what exactly the decision in Fleck is going to be?
Is that an open question?
Yes.
Yeah.
I'm going to sit back and see if anyone else wants to respond to it before I jump in.
for those of us that have led voluntary bars, it's, you know, we have just very different, we have some of the same problem in terms of, obviously we're afraid to lose members, and so many of us are in declining membership problems that I think the American Bar Association itself has experienced, and many local as well as voluntary state bars have faced. And so that certainly does offer some constraint on the positions we might take, because we don't want to lose members. But of course, there are a whole set of other issues. You know, mandatory bars don't have to worry about getting members to join and getting members retained. And that takes up, I think, a whole lot of the time of a voluntary bar. So it's not exactly a panacea out there to start up a voluntary organization. And I'm happy to hear, Emilio, that you haven't suffered in loss of membership, at least not yet.
No, we haven't, and we hope it stays that way. In fact, we're thinking through strategies to actually grow our members. So to go beyond the members that we had under the state bar, precisely because we have more flexibility. So look, avoiding taking a political position is important to us, like it's important to any other bar association. Working through, you know, why bar associations are losing members and trying to learn from all of you so we don't lose members is important. But, you know, look, membership in the sections was voluntary even prior to separation. So sections had to always think about how do they bring in members. Now that challenge is added because we're separate. But it's also an opportunity because we are separate. We can think about ways to market ourselves to get more members that we could never think about when we were with the state bar, given the environment in California. I want to be clear, I'm not drawing any sort of implications for any other state because California has its own unique environment. So in short, I think while we are always going to be careful not to take a political position, the fact that we have more flexibility for us, given our situation, will be a way in which we can attract more members onto the professional association side so that we can do things together as attorneys and together as sections that we could never do on our own separately. And so we have a number of initiatives in that respect, and such as access to justice, such as civic education, and diversity, equity, and inclusion that we are working hard on together.
So Janet, do you think there will be a possible voluntary bar in Michigan in the offing?
Well, I really appreciated Emilio's response because I think it's true that every state is unique, and that people who think that that there's a new model being born, or that it's an extension of what Virginia and North Carolina and West Virginia have, I think will be surprised, because North Carolina does not look like Virginia, and Virginia doesn't look like California. I think that if the US Supreme Court sort of used a meat cleaver approach in a decision that said, no, you're exactly like unions, and so mandatory bars can't exist. You don't have to belong to a mandatory bar in order to practice law. Then I think that there would be a voluntary state bar, because we just do so much. We have so many activities that people are committed to. I think it would be an inefficient response, and I think it would degrade the regulation of the profession and administration of justice in Michigan, at least in the short term, and and that short term would be not so short. So that's my 2 cents worth on the issue.
Well, we have about 10 more minutes. I wonder if any of our participants have any comments or questions. We'd love to hear from you and what your experiences are, and whether or not any of you have changed the way you conduct business because of the pendency of the FLEC cert petition. I want to give everybody about a minute to type, since people are chatting. There's a chat function. If you haven't found it, there's a chat function where you can post questions or make a comment. And while we're waiting to see if there are any, I wanted to do a plug for a program on this subject that will be an interactive program, because it's one of our interactive workshops on Friday, January 25 in Las Vegas, as part of the NCBP mid-year and ABA mid-year meetings. That Friday at 10:30, there is a workshop specifically on how mandatory bars have reacted to Janus and FLEC, and whether or not they need to do some planning in light of what may or may not be the Supreme Court's decision. And so if you want a deeper dive into this and be able to discuss with each other in a little bit more interactive setting, we certainly encourage you, if you're not already registered for the NCBP program, to come to the program, which I'm sure is going to be a really terrific one. So I don't see any questions or comments from the participants. So I want to give, so here is a general question to the panelists. What should mandatory bars do now? Should they do anything differently given the pendency of FLEC? What does a smart mandatory bar do now to plan in case of an eventual decision in FLEC running the gamut from, as you described it, a meat cleaver decision to one that might be a little bit more circumspect? Nobody wants to venture a guess?
I could say one thing, because I'm not sure that this distinction has been teased out enough. And it comes from something Janet said earlier. There's a difference in my mind between the state bar, any state bar's licensing functions and discipline functions, and even policing the unauthorized practice of law, although that varies a lot from state to state. There are a lot of states that don't do that the way California does and leave it up to the state bar. But to me, that's a little different than everything else the state bar does in any state. And so if at the end of the day, FLEC comes out, a certain way, let's say in a way that says that, yes, what Janice said about unions applies to state bars. And after whatever point in time, the U.S. Supreme Court does the same thing, it might be worth it in terms of planning, in terms of how that issue gets briefed, to think through all the different things that a state bar does and compare that to what was at issue in Janus and sort of decide, okay, what is it really that the state bar should be able to do that doesn't really involve the same issues as unions? Unions don't license people, at least not in this country. How it happens overseas is interesting, but not here. They certainly don't have the force of government authority in terms of disciplining members who have done things that have violated, for example, ethical rules or legal rules in the practice of law. They don't have to police the good standing of the members. You know, have they, for example, committed a felony that says that they shouldn't be a lawyer anymore? And so I think all of that really kind of needs to be teased out here. I mean, the sort of easier question, so to speak, is the discussion we've been having about the professional association function. But there are much harder questions involved with the state bar that I think arguably, and just listening to this as an outsider, were not necessarily teed up when you thought about unions in Janus.
So Emilio, I really appreciate that answer, because that's exactly what the mandatory bar states right now are organizing to do. We're taking an inventory of what exactly we do and how it fits within the regulatory scheme of our states, because in the end, we can only justify our existence as a mandatory bar association to the extent that what we do promotes the public interest, not the interest of the individual lawyers in the state. So we're engaged in that, and trying to do sort of a taxonomy of the extent to which our activities are exclusively regulatory or support the regulatory function, and then how, in order to help actually, in the end, help the US Supreme Court understand the extent to which mandatory bars are embedded within the regulatory activities of and the administration of justice in each of the states, and that the decision makers in the states, the state Supreme Court justices and the legislatures have made decisions that that is the most efficient and effective way to carry out what they see as the public interest in the administration of justice and in the regulation of the profession.
But perhaps to leave this as the thought, and that is, if the Supreme Court decides black in such a way that mandatory bars are only permitted to do the regulatory function and are not permitted to do even activities that may be considered ancillary to that, even if they're in the public interest. The bottom line is that then the best way to regulate the profession? Or is it time then to perhaps relook at the model the voluntary bar states have, where it's the court that oversees the lawyers and the court oversees the regulatory function, leaving bar associations to do what's in the best interest of lawyers?
Well, even in mandatory bar states, it's the court that makes that decision now. So that it would be in my opinion, it would be a very activist court that would say that even ancillary regulatory activities are outside the bounds of a bar association if the state itself chooses to use the vehicle of the bar to carry out those functions. But I look forward to the conversation and the challenge if we end up in that world.
Well, thank you very much, Janet and Emilio, and thank you to all of the participants, especially those who added to the discussion. There seems to be a lot of interest in this subject, and I hope that we'll have a great turnout at the program in Las Vegas. Again, that's Friday, January 25 at 10:30 as a workshop. And who knows, maybe we'll be back after Fleck has decided on needing to talk about a whole new set of subjects. So thanks again to everyone. And
Thank you for having us.
Thank you so much.